ನಾನು ಜಾಸ್ತಿ ಹೇಳಕ್ ಹೋಗಲ್ಲ. ಅದೇ ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಆಮೇಲೆ ಏನಾದಂದ್ರೆ ನನಗೇನು ಹೇಳ್ಬಾರ್ದು, ಅರ್ಥ ಆಯ್ತಾ? ನಮ್ದು ಅದು ನನಗೆ ಗೊತ್ತು. Assalamu
Not sitting, no sitting. Tomorrow, yes. All right, sir. Yes, what urgency? What urgency? Yes. They are what doing what?
They're carrying out the, they're taking away the marks. Yeah. And other platform for IA, they are not in the same company, you are not in the second time.
It seems to be difficult, but still we will. Once these matters are over, please mention. Rectification of amended cost estimate. Each type. That's fine. How much time? When it counsel for the appellant undertakes to supply a copy of memo of appeal along with annexures to Mr. Hemant Kumar D, who
Yes, ma'am.
appears with appeal correspondent. Office is directed to reflect his name as counsel correspondent. In view of opposite office objection is ignored. Next. But for the appellant. Third time. This appeal is listed for the third time for non-payment of process fees. Honorary counsel for the appellant once again prays for adjournment. 2 weeks time is granted to comply with office objections, failing which appeal shall stand dismissed without appeal. Second. Honorary counsel for the appellant while inviting attention of this court to the memorandum of agreement recorded by the Bangalore Mediation Center submits that the dispute between the parties has been amicably settled. The terms and conditions of the compromise read as under 1 to 7. Page number 2, 1 to 7. What they have adding on the marriage performed between the parties. The terms of compromise arrived at between the parties. The marriage performed resolved by a decree of divorce and the appeal is disposed of in terms of this instead for the third time for non-payment of process fee. They prays for adjournment by way of indulgence. 2 weeks failing which shall stand dismissed. Which company?
Division of the matter in the government.
1,000. 24 you can actually pay. For that, they can't ask another bank guarantee, another agreement. They wanted that I am not an employee, I am not entitled for regular single year, they are entitled for single. How did it come in the way of paying a revision? Many of them have been paid. 60%. You. We are getting, we are getting 12,000 rupees per month. No, who has not got? That's what he's saying, that if you tell him that these people are, these employees have not got, so then perhaps we can ensure the compliance, right? These different terms. I mean, if you want specific names of the employees, that you can say that these persons have not been given the benefit of the revision of pay, whatever, right? You are not college next week. College next week. And the date of hearing. We are also. Details to the money is paid. So the and the details. You know, at least for the money. No, but it's better. No, it's better. I mean, you must be knowing who has not got it, right? Better so that we can. It's no, it is necessary because then we can ensure effective implementation. Its senior council correspondents undertake to furnish the details of the employees who benefit of what? Revision of salary. Revision of remuneration stroke salary has not been extended, right? So what? When do you want? Revision of salary and incentive 5%. Revision of salary, incentives, stroke whatever remuneration, right? Next week you will ask. So then, when by what time will you supply? Like what date? List on 6th of July 20. We'll fix it on 6th. Filing of objections, further orders, condonation of delay. This IA1 of 22 can be allowed, right? Yes, Mr. Lakshmi Narayan. Date has to be condoned this. Yes. And this IA2 of 22 we shall allow, right? Mark everybody's presence heard on IA1 of 22 reasons assigned to allowed. So before that you write. Heard on IA1 of 21, right? Delay condoned, IA allowed. Then 1 of 22 allowed. Let cost that will be amended within 1 week. Let the appeal be listed for orders on admission thereafter. Interim order, if any granted on earlier occasion, shall continue. Okay. On filing of the council, the applicant undertakes to file the original copy of the paper publication during the course of the day. The office objection is therefore note what is 1 of 22 complied with. Transposition of appellant number 2. Anybody is opposing? Let the appeal be listed for order from admission in the next. Government educate. That. What is it? Notice has to be issued. When have you filed? Current counsel for the applicant submits an application seeking substitute note allowed for disease response number 3A has been filed on. PG has been filed on what date? 21st June 2023. Notice of the opposite IA. What is IA number? Opposite IA to propose the loss of disease respondent number 3G. After restoration also. Huh? After restoration, Mr. This is what we are saying, that even after seeking restoration, you are not complying and seeking time. That means appellant doesn't want to prosecute this appeal. That's it. Current counsel for the appellant respondent is granted 2 weeks time to be available. Well, the government educate. Who is retaining? Your wife. Huh? Have you supplied a copy? Huh? 12. Huh? Great. Except undertakes to comply with office objections within 3 days, heard on the question of admission. Then Mr. Hegde undertakes to accept notice. SPP2 accepts notice on behalf of 1 to 3. Issue notice to respondent 4 to 6. Why 1 week time? Huh? Application for section 5 has been dismissed, right? That how appeal lies. That's the objection. See, Mr. Against which order they are mentioned here. It does not say against an order rejecting an application for condonation of delay. Read it aloud, 47. Read. We have not read it, so therefore please read. Section 5.
This is the second one, very admin. Petition upload. 26.
Section 5 of the act.
It's an allowed.
Under section 5, what they say is what is section? So you have seen that it does not provide for an appeal under section 5 of the Guardian and Wards Act, correct? What is section 5 of Guardian and Wards Act? Read. Therefore, you will have to challenge it before an appropriate forum, right?
Totally unconcerned. However, we have arranged to appoint in case of European legislature. Section 12.
Section 7. What is presence? Yeah, there is the interim order dated 7/6/2023. The order appears the order has been passed on a petition filed under section 7 of the Guardian and Watch Act. However, it appears that on account of typographical error in the order, reference has been made to a petition under section 5 of the Act. So therefore, the appeal is held to be maintainable under section 47A of the Guardian and Watch. The same is admitted for hearing. Issue notice record. You must be able to tell Mr. Counsel what will happen. Supposing if we don't read, you are even unable to tell us that how it is. What you should have told that no Guardian and Watch court, the court has made a reference to section 5, but it is a petition under section 7. What happens to the client? They are left at the mercy of the court. What after filing of the appeal? You won't do anything. They are left at our discretion. We may dismiss, allow whatever we feel like. Why you did not tell us? Prepared.
Number 40.
My lord, I'm appearing for respondent in this matter. I'll collect a copy, my lord, of the application from my friend.
Substitution we will allow, no? What's there?
My lord, I'll just take instructions on that matter, my lord, regarding the application.
Who is
My lord.
appearing? We are.
My lord, some technical issue, my lord.
Who is appearing for respondent?
I'm for respondent, my lord. Vivek BN for Abhinav R.
Mr. Vivek BN, learned counsel, prays for adjournment in order to enable him to seek instructions and to file objections to IA 1 of 22 if so advised, list after 1 week.
Published.
50. The Ashok Kumar ticket.
What? Condonation, right? Heard on IA 1 of 20 reason assigned to delay of 91 days in 5. We find sufficient cause. Delay condoned IA's law. What vacating stay? One 2020. And when the limitation expired? Huh? Okay. So that's fine. We have condoned the delay, but what happens to your appeal? He has got married. Will you, so even if you are, please understand that even if you succeed in your appeal, you won't go and live with him. Not possible, right? Therefore, seek instruction. You condone the delay, madam, there is no problem. We are talking about what he is telling us. You understand, like even if the decree is set aside right now, what happens? Client will go and start living with him. Is along with his second wife, will you live? Be practical, you understand, right? Current counsel for respondent submits heard on IA 1 of 23. Current counsel for respondent submits that that the limitation for filing the appeal expired on 21/9/2019 and the respondent got 21/9. Well, 21/12/2019, right? 21/12/2019. And whereas the respondent has already got married on 8/1/2020. Full stop. In view of proposal submission, learned counsel for the appellant prays for adjournment. We people are to seek instructions. List after 3 weeks. Yes, madam, you also file. Mr. Assets and liabilities statement you file. That's the only dispute according to us now which survives. Subject to what she argued. Parties are directed to file an affidavit of pertaining to their assets and liabilities in view of law laid down in so on. Right? Parties are directed to file an affidavit pertaining to assets and liabilities on or before next date of hearing, then say list after 3 weeks. Hearing, who has filed? What is it? Section. Suit. What has come? You have to in time when we can hear. That's not called for. Not called for. Appeal is admitted to. Yes. Let IA 3 of 23 be listed for consideration immediately after receipt of the record. What should be necessary, Mr. Joint submission records are not necessary. That's what we have done. See, Mr. It's not that we'll pass an order thereafter. We'll explain the impact of the order. It's not. We are not supposed to do it. We have said that record. If you want record not to be called, we will say so. That he agrees that it appeal be heard without record. You are agreeing?
He doesn't require records. Whether you want records.
Learned counsel for the parties jointly submit that the record may not be requisitioned as they are ready to argue the appeal without record. Let IA 3 of 23 be listed for consideration in commencing 24 July 23. Yes.
At least they must have records.
And you will not comply with office objection, right? It will come up again. Yes. Only on that condition we will recall. Undertakes to comply with office objection within 1 week, failing which what you will do? No, supposing if you don't comply, what happens? We are out. That even otherwise you are bound, right? Even if you don't give. Subject to aforesaid undertaking, order dated 15/12/2022 record. Store to file IA allowed. Take control IA allowed the store to file. Takes to comply with office objection within 2 weeks. Subject to so and so delay control. Same order 19. Now they are amended, the commercial appeals are pending. It is 27th March. So after 3 months, you are all of a sudden you are reminded that appeal has been dismissed. So commercial, how much office, within how much time? Subject to compliance with office objects. 2 weeks, so and so recalled. 21. Learned counsel for the apparent threshold is granted. Weeks time to enable him to file objections to IA2 of 20. List for analogous hearing along with MFA number. IA 1 of 23 record.
I appear for the appellant, my lordship. I need a short accommodation, my lordship. 1 week's time may be granted. I'm not keeping well. I need to argue this, please. 1 week time, please.
2022, you are seeking adjournment October 22.
This is finally, my lordship. 1 week, please. I'll appear in person and argue.
So this video conferencing facility is to seek adjournment, right? Then you there from there appearing, you say that I will appear in person and argue. So this facility we have created for seeking adjournment, right?
No, my lordship. Today I'm really not feeling well. That is the.
What's your name?
Feroz Nizam.
Read counsel for the appellant appears through video conferencing and submits that he is unwell. Idea of indulgence hearing is deferred. List after 2 weeks.
Obligement.
Next date, please argue.
Yes.
My lords, in this, I appear for the respondent, my lords, in serial number 24.
Yes.
My lords, I seek your lordship's indulgence in filing objections to the MSM, to the appeal, my lords. It was served on this.
Under which provision you are filing objection?
To appeal.
My lords?
Under which provision? Which
My lords,
provision enables you to file objection in appeal?
My lords, it is the fact is that, my lords, we need to bring certain facts on this thing, my lords, on record, my lords. That's the reason, my lords.
Then file an affidavit, right? Additional facts on record. An application seeking additional facts on record, not objection. Like supposing if a decree of divorce is granted by the matrimonial court, can a respondent file objection in an appeal? Tell us. So, is there any time period for which a order of provisional attachment is in force? This order has been set aside before, before it's like appeal is admitted for hearing. State counsel correspondent may file an affidavit if so advised within 2 weeks.
Grateful.
25. Office is directed to issue a reminder to requisition the record. Happen. Right, appeal granted. Appeal is a hearing. You have filed You have file of the case. Because you are the senior counsel, right? No, you don't have, you said you don't have file. You have the file. So who has filed this appeal? No, who has filed the appeal? P means who? Did we ask what is the appellant's name? By whom, Mr. Matrimonial dispute, who will file an appeal? Either husband or wife. Who has filed? Simple, right? Why is it so difficult, right? Answer 2 plus 2 is what? Husband has filed. So what happened against what judgment and decree?
Against decree of restitution of conjugal tax.
Who has filed the petition? You had filed the petition?
Here for the petitioners, this case, NC number, PP of 2011.
See, dismiss.
In the sequence of the-
Direction to recall the wife. to the matrimonial.
What ground? What ground nullity?
Marriage is specifically solemnized in 15th of September. Registered in the office of Register of Deeds. The thing alleges that the marriage and the resolution was not with his free consent. The secured with fraud and false. Order here is-
Husband's consent. Husband's consent.
Submitted for a issue notice by court. Look, Mr. In miscellaneous first appeals, when the matter is listed for admission, don't seek adjournment. Law provides for an appeal. You should know that much. What senior will argue? If senior argues everything, what will you do? Seek adjournment, right? Huh? Mastering the art of adjournment, correct? Huh? Right? Making an effort to master the art of adjournment, right? We had created this video conferencing facility for argument. You people have turned it into an like instrument of seeking adjournment. So there you appear and say that I will appear in person. Therefore, adjourned, it be adjourned. Yes. Let's see. Reasons.
Once mentioned. Listen,
Yes, Mr. What are the reasons assigned by the court for rejecting his objections under section 34? What is reasons, please? Where, which paragraph the commercial court has assigned reasons? That's all. That is the order in appeal, right? Come, you are not visible to me. Come slightly this side. Which paragraph commercial court has assigned reasons for rejecting the petition under section 34? And what are those reasons? No reason, right? So what should be done? It has to be remitted. We will tell the commercial court to decide it expeditiously within an outer limit of 3 months. Huh? 3 months, we said 3 months. Yes, this appeal under section 37(1)(b) of the Arbitration and Conciliation Act. Arbitration and Conciliation Act 1996, 31C, 37(1)(c) of the Arbitration and Conciliation Act 1996 has been filed against judgment dated 19th of June 2019, passed by the commercial court, passed by the trial court, by which filed by the appellant under section 34 of the Arbitration and Conciliation Act 1996 has been rejected. Taking into account the nature of proposed order which we pass in this, so after hearing the taking into account the nature of order which we propose to pass, after hearing learned counsel for the parties at length, it is not necessary to advertise the facts. Then paragraph. You know that requirement of assigning reasons in any quasi-judicial court is required to, right? In view of aforesaid enunciation of law, it is evident that requirement of assigning the reasons have been held to be part of principles of natural justice by Honorable the Supreme Court. Full stop. From approval of the judgment dated 19th of June 2019, passed by the trial court, it is evident that no reasons have been assigned by the trial court while rejecting the objection preferred by the appellant. Full stop. The trial court has merely reproduced section 34 of the Act, and in para 16 has held that no grounds to interfere with the findings of arbitrator are made out. The impugned judgment therefore cannot be sustained in the eye of law. It is set aside. The matter is remitted to the court to decide, to the trial court to decide the matter afresh, after hearing the parties within an outer limit of 3 months. Accordingly, the appeal is disposed of. Order what you have deposited by the appellant in compliance of the interim order passed by this court be refunded to.
I appear for the appellant, my lord. I appear for the appellant. My lord, this is a case wherein, if I may draw your lordship kind attention to page 542, wherein I have produced a gazette notification. My lord, the IBC code came into force in 2016, but there was a winding up proceedings in a company petition already pending on the file of this honorable court way back in 2012. My lord, the gazette notification says that in whatever matter the company petitions are pending, where notice has been served, in such cases, my lord, the winding up proceeding will continue before the Honorable High Court. Ignoring these facts, my lord, the company proceeded on the basis of collusion with KSFC before the NCLT. My lord, several cases of mine settled before the Lok Adalat are sought to be scuttled in spite of obtaining a decree. My lord, these facts have not been considered by the learned judge. If your lordship may take the gazette notification annexure F 542.
Where did you argue this point?
Beg your pardon?
This contention was not raised before the learned single judge, right?
My lord, I did raise this contention. My learned judge has earlier passed an order. I took out a ground. Stay was granted. It was not set down for hearing. My lord, the learned judge proceeded to pass a final order on the writ petition, dismissing my writ petitions. My lord, this was the position of law prevailing then also. My lord, with great respect, I may say so.
Was it the ground raised in the writ petition?
Where is it?
If I remember correctly, yes, my lord. Sorry for
What is submission? What's your submission, Mr.?
My humble submission is
Ah.
that in any winding up proceeding that is filed before the Honorable High Court, where the notice has been served on the respondent, in such matters, the matter will not be referred to the NCLT under the IBC Court, but the winding up proceeding shall be adjudicated by the Honorable High Court only. Such being the case, my lord, several cases of mine.
Right. So therefore, the facts have to be pleaded to prove what you are arguing. So that's why, please tell us, where have you have fairly conceded that there is no reference to these facts in the order passed by learned single judge.
My lord,
Where have you pleaded in the writ petition?
my lord,
You cannot argue anything new, Mr.
no, I'm not.
Tell us which paragraph of the writ petition you had urged that contention. Mr. What writ? Which page writ petition? Mr. All right. Yes. Which para? All right. Yes, Mr. Anything else?
My lord, this apart, my lord, that
Ah.
the initiation of the proceeding by the KSFC was a time-barred proceedings. Way back in 2010, my lord, they had initiated the proceedings for recovery under section 29. They did not pursue that matter, yet proceeded to initiate proceeding under the IBC code. These are the grounds which I have urged in my writ petitions. My lord, these matters, without considering that, my orders, my beneficial orders which I got in the settlement before the Lok Adalat is sought to be scuttled because these matters were suppressed by the company. Therefore, my lord, the other respondents should also be notified by issuance of notice such that there is no miscarriage of justice, my lord. Only the caveator has submitted in this, they have entered appearance. The other respondents have not appeared.
So therefore, writ petition cannot be decided until unless they appear.
No, my lord, in writ petition they did appear, my lord, but in the writ appeal, my lord, only the caveator has been served.
No, we are hearing you on admission, Mr.
Yes, my lord.
Take out a case for admission, then only notice will be issued.
Yes, my lord. So far as
where the writ appeal is filed, notice should be automatically issued.
No,
In
my
that
lord,
case, it should be more registrar judicial. It does not require any application of mine. Why to waste our time?
My lord, the position of law is
position of law is 2021 volume 4 SCC 435. That is the position of law. Yes. What else?
The gazette notification is self-explanatory, and the Calcutta judgment I have produced it, my lord. The Calcutta judgment at page 542, my lord, 594, squarely is on the same lines that any proceeding which is pending in a winding up proceeding cannot be taken up by the IBC code.
Yes, correct. Anything else?
That's my submission, man.
Or this intra-court appeal has been filed against an order dated 22nd December 2020, passed by learned single judge, by which writ petition filed by the petitioner to set aside the order dated 17/8/2020, passed by the National Company Law Tribunal, has been dismissed. Paragraph. Facts giving rise to filing of this appeal briefly stated are that KSFC, Karnataka State Financial Corporation, filed a petition under Section 7 of the IBC 2016, which was admitted before the National Company Law Tribunal, which was admitted by full stop. The appellant approached the tribunal with this claim, and the respondent number 3 sent 2 communications dated 28/9/2020 and 21/10/2020. Full stop. The National Company Law Tribunal. But you should have given it right in the beginning. The National Company Law Tribunal by an order dated 17/8/2020 has directed to convene a meeting of secure creditors on 26/9/2020. The aforesaid order has been passed in a proceeding relating to approval of scheme consented to by the secured creditors of the company. Full stop. The learned single judge by an order dated so and so dismissed the writ petition. Paragraph. Learned counsel for the appellant submitted that since the matter pertaining to winding up of the company was pending before the High Court, therefore the corporation could not have initiated the proceeding under Section 7 of the Act and the national before the National Law Tribunal, and the tribunal could not have passed the impugned order dated 17/8/2020. Full stop. Paragraph. On the other end, continuation. On the other end, learned counsel correspondent has supported the order passed by the learned single judge. Paragraph. So and full stop. The issue involved in this intra-court appeal raised by the issue raised by learned counsel for the appellant is squarely covered by decision of Honorable Supreme Court in so and so versus so and so 2021 Volume 4 SSC 435, wherein Honorable the Supreme Court has held that the pendency of winding up proceedings is not a bar to proceeding under Section 7 or 9 of the IBC, as the proceeding under Section 7 and 9 of the IBC are independent and are overriding proceeding. Full stop. In view of opposite enunciation of law by Honorable the Supreme Court, the contention raised by learned counsel for the appellant does not deserve acceptance in the result. Do not find any merit in this appeal. Say fails and no, how do you say like this available warrant was issued against the chief law officer, right? Yes. Managing director. So how chief law officer can maintain? Who appears to respond? Not appearing. They don't want to oppose the prayer. That's why they are not appearing, right? You are required to serve this publication. Mark the presence. None for respondent, those served. This intra-court appeal takes an exception to an order dated 17th of December 2020 passed by learned single judge, by which writ petition is referred by the appellant challenging the order dated 21/4/2016 passed by the Karnataka State Scheduled Caste and Scheduled Tribes Commission has been dismissed. Paragraph, right? Giving rise to filing of this appeal. Briefly stated, who had initiated a proceeding? Briefly stated out that the respondent number one, what proceeding? Facts giving rise to filing of this appeal briefly stated out that respondent number one is an employee of the Karnataka State Road Transport Corporation, herein after referred to as the corporation. The respondent number one was transferred by an order dated 16/11/2010 from Ramnagara Division 2 from Bangalore Division to Ramnagara Division for being agreed by the order of transfer, it appears that respondent number one approached so and so commission, right? Herein after referred commission. Full stop in the opposite proceeding, Karnataka's in the opposite proceeding, commission issued a bailable warrant to the managing director, Karnataka State Road Transport Corporation on 21/4/2016. Full stop the paragraph, the opposite order. So what happened to the proceeding? Still pending. So you will be appearing right regularly. The corporation challenged the opposite order dated 21/4/2016 in a writ petition. Learned single judge by an order dated 17th of December 2020 dismissed the writ petition on the ground that managing director of the corporation cannot delegate the powers to the chief law officer to file the petition with regard to challenge to the impugned order dated 21/4/2016. Paragraph. We have heard learned counsel for the appellant at length. None has appeared on behalf of respondent, even though served. Full stop. Paragraph. It is pertinent to note that the authority of the chief law officer to represent the managing director of the corporation was not under challenge in the writ petition. Therefore, the learned single judge heard in holding that the chief law officer could not represent the managing director and challenge the order dated 21/4/2016. Full stop. But it is stated on behalf of the corporation that the divisional manager shall regularly appear in the proceeding before the commission, which are still pending. Full stop. For the aforementioned reasons, order dated 17 December 2020 passed by learned single judge in WP number 25167/2016 is quashed. In the result, appeal is allowed. Regional manager through advocate will appear regularly. Yes. What? Is your submission, Mr. You have admitted this appeal.
Heard for some time.
Admitted, yes. You could tell us that it has been admitted, right? It's not admitted. Admitted, yes. That's not why removed. He has given us a synopsis. Right, you say that this land is different. We hear it. Appeal is admitted for hearing. What is non-filing of substitution and of LRs? 30.1. Not to file. Huh? How much time? Admitted. How much time? 30.1. You have to make an application for substitution. Correct. 30.1. Merit counsel for the applicant based on 2 weeks time to enable him to move an application. The substitution of LRs will be used to have respondent for So you received a warning, right? Thereafter a show cause notice was given. 8 months. Where is that? That you did not receive any warning and show cause notice. Is it a ground in the petition? Please show that you never served a copy of this memorandum as well as the show cause notice and everything you did. Dismissal order was also not served. Which page? Page 31. Yes. So that's fine. That where is your case that you did not receive these notices? Where you should say so. What you are telling us in the petition, not orally subsequently after dismissal. You should say so that I did not receive. Then it's not there.
He has replied. That means he's admitting the notice. See your ground number 13. What you have said is you have received the notice, orally you have replied. That is your case. Now you are saying that notice is not received.
No, page. Come to page para 13, page 32 first. Read it. Therefore, that you didn't receive incorrect. What can be? So supposing you remain absent for 8 months from your job, what inference? No, we don't have any issue. He is willing to give you an order of appointment. You approach him. There is the age of Anganwadi assistants. Age
Age of
of
retirement.
retirement. Then you have already attained age of retirement. no restatement, and if you don't, you cannot be permitted to continue beyond the age of superannuation. Correct? Because there's no retirement benefits. Any retirement benefits? No. So that is not the prayer list. Nobody is denying you process of provident fund and all. Not something you should argue.
It is not withheld. It is not withheld.
You have only sought reinstatement and quashment. So you make a claim. If you are entitled, you will get it. Not in writ appeal, right? Traveling beyond scope of the petition. This appeal. Approach them, Mr. And if they deny, then file a writ petition. Correct? Yes, this appeal, this intra-court appeal under Section 4 of Karnataka High Court Act 1961 has been filed against an order dated 19 July 2021 passed by the single judge, by which writ petition preferred by the appellant challenging the order dated 16/12/2015 by which her services were terminated from the post of Anganwadi assistant. Anganwadi assistant, has been dismissed. Paragraph facts giving rise to filing of this appeal briefly stated are that the appellant was appointed on 9/4/1996 as an Anganwadi assistant in Nihal village, Chitradurga district. It appears that some complaints were made against the appellant with regard to her behavior. Full stop. Thereupon, a memorandum dated 31/12/2014 was issued to the petitioner by which she was warned about her conduct. Full stop. Thereafter, a warning notice. Thereafter, a show cause notice dated 26/2015 was issued to the appellant for remaining unauthorizedly absent from her duties. Full stop. The appellant neither submitted any reply to the aforesaid notice even after a lapse of 8 months, nor she attended her duties. The appellant remained unauthorizedly absent from her duties. Thereafter, a final notice dated 16/10/2015 was issued. The appellant again failed to respond to the aforesaid final notice. Neither responded to the aforesaid final notice nor reported for duties. Thereupon, by an order dated 16/12/2015, the services of the appellant were terminated. Paragraph. The appellant challenged the aforesaid order in the writ petition before the learned single judge, who by an order dated so and so 19th of July 21 has dismissed the writ petition. Full stop. The learned single judge from the conduct of the appellant in not responding to the notices and in remaining continuously unauthorized absent for a period of more than 8 months without any intimation has rightly concluded that the appellant had voluntarily abandoned her service. Full stop. Therefore, we do not find any ground to differ with the view taken by learned single judge in the result appeal phase. Yes. 32. Will file objection to what? Better affidavit. How much time? Current counsel for respondent Pressford is granted a week's time to enable him to file an affidavit to the application filed by the filed on behalf of the appellant seeking condonation of delay. 67 acres. And lakhs. Plenty. Yes. 15,000. 79,000. We have no right to claim why he says that not entitled to use a FAR? Why? That you are not entitled. That is the dispute between the parties, whether you are entitled to construct. That that order of injunction doesn't affect you, right? That order of injunction doesn't affect you if you have already utilized. Yes. Development plan dated. What's the date? So we'll say that if not already utilized, right? If not already utilized. All right, yes. Yes, yes. Yes. Is it dated? Seventeen 2022. He has given us. Along with your statement of objections dated 17/9.
Yes.
Which? Page 80. Yes, yes. Yes. Yes, clause 6. Yes. The remaining part of the order says that we create a charge in respect of the area, right?
Just complete the, just do not back.
Yes.
Oh. Area of the, I mean, these agreement is 17. That works out to 77,000, 7,74,278 square. The lot of turns over the page. The area occupied by roads, the access is about 2 acres. Therefore, the net plot area available for development is 50 acres. Say we are on ad item. Now, this 50 acres, 23 acres works out to about 66, 28,050 square. That was 50.5 into this comes about 16 units, 26,054 square. So you just make a pencil now. 16.96 square. Square. What with that? Out of that, constructed is. But item, you see, area constructed is 976,000. But that's 16. What dispute is regarding 6 lakhs. Remaining areas of 67. The lordship sees what the agreement said. They can ask, kindly come back to this agreement. Page 49 of my statement of opinion, paragraph number 9. Yes. And when we are struck on area exceeding 10 acres, but in various importance for 56. But various laws. decision. How complicated to be any what? Stater to get transferred to itself. Can say what to get transferred to itself. All the receive. This is something in this making sale agreement with same except letting the law the necessity to attach it fits to the review of Indians. Any time after the or this these are not it. Second, suppose he wants for no third parties by utilizing the internet. Transfer by the receiver. Or 20 years from the date after 12 years, I came here. We have not constructed more than 10 years. I exercise my right. That's why the suit is right at 17. So this 21 day 2017 is 12 years from the date of this. It's 31. It's 31. This agreement in 2017, I think its works get back reversionary and residuary right in excess of 10 years. So what did he do? What the plan? What he utilized it. What is the paper? He has not constructed that. Taking a sanction for X amount.
Yes.
Because even yeah. Page 94. About the page of the trial judge says I have made out the prima facie case. He also says that we keep going to integrity, we put in the rolling end. Please see what he says at page 58. Paragraph 58. He apprehends that the defendants would write of creating the charge with balance FIR available and on 17 with respect to the video. The defendant create a charge with respect to the unutilized balance FIR available on and comes also in order to deal with the case, right under the prevent it from utilizing the same. Right? October 21st, 2017. That the defendant say the allegations. However, the defendant exceeding so and so modified in some is really negative. The purpose of that invention is to preserve and protect the property invested. The debate is to prevent circumstances of painting of the balance of the painting is stating that the Supreme Court want to increase based on the party under the PPA. If 17, which is going to violate of government the covenant defined in the PPA, if you call the irreparable loss of injury to the state, in order to protect the interests of both the parties, if 17 is not restrained as paid by the king, you need to Sorry, the statement utilizing very good. And see, when it tried that, has calculated this, see, that 7 agree to that the total extent of deviation are 67 acres and very good that is known to very. The total extent of that prior to rain 17 acres, the extent of 2 acres 7.7 meters of rain. Now the total extent of 50 acres that is one of very the rest he says this week. Area was 65,000 square feet and both square feet and square meters are there. You want to go square feet. Area section was 23 and 27. Then in 2013, as for a 1 acre, 43,000. And in 2015, it was so what we see is 2030. They can be constructed on this side of this. Only to these two main in this 40 2 years. They speak. In the context, then we can say faster than that is going on is used for cross examination.
Reserved for others. Yes. 34. Siddharth Kumar. Availability. So you want time to correct this thing. File an application. Unit counsel for the applicant submits that the order dated 24/5/2021 passed by the family court is an order applicable under order 43 rule 1 within bracket small a of the code of civil procedure. We therefore praise for how much praise for it is granted a week's time to enable him to convert this application, convert this appeal into an appeal under order 43 rule 1A of the code of civil procedure. 35.
My lord, I am appearing for appellant. My lord, appellant has
Appeal
filed.
is, yes, appeal is admitted for hearing. Issue notice, office is directed to secure the record of the family court.
Okay.
36.
And for the respondent, it is an appeal, not.
36. Yes. 1 minute.
Loud.
So, the senior counsel for the applicant clearly submits that against an order dated against the order dated 4th of March 2023, appeal under section 13 within bracket 1A of the Commercial Courts Act 2015 as by the impugned order, the commercial court has rejected the application filed by defendant number 7 for return of place. So he therefore seeks leave of this court to withdraw the appeal with the liberty to challenge the order dated 4th of March 2023 in a writ petition. Office is directed to return certified copy of the order dated 4th of March 2023 to learned counsel to Mr. So-and-so learned counsel. With the accordingly, the appeal is disposed of. Dismissed as before. 37. Learned Shashi Kiran Shetty, learned senior counsel, the applicant, so and to learned counsel for respondent place for short accommodation to enable him to seek instructions in the light of affidavit filed on behalf of the applicant. Right. List on when do you want? 5th July. 5th July 20. We hope it's not a Sunday, right? Not a Sunday. 5th July. Was it is it. People often prefer Sunday, Saturday. That's why. Right, wait. You are willing to pay. They are unable to compute what is the amount due. So, he is seeking time to tell us what is the amount due. So it is expected that he won't take any action, right? Huh? Why? Ah. Ah. Huh? Ah, correct. Second time. Right. Then, say Monday, third, not Friday, 3rd July. Huh? So 3rd July, please argue. Learned counsel for the appellant prays for adjournment on the ground that arguing counsel is not available on account of personal difficulty. Learned counsel for respondent has pointed out that on an earlier occasion also the appellant had short time in view of approaches submission. Learned counsel for the appellant states before this court that on the next date of hearing, the appeal shall be argued positively on the question of admission and no adjournment shall be sought. Right? Means on 3rd July 23, interim order shall. That's most important thing, right? Interim order shall continue till then. 39 also.
The party, have you interacted? The committee accept?
Appeal is admitted for hearing. Notice on behalf of this state is accepted by learned counsel. Office is directed to secure the record of the commercial court. Then 5. So, stay. So what? We don't grant under unconditional stay of a money decree. How much will you pay? No. For 50, but there is no objection by the office. You can raise an objection, we will consider it, right? Mr. Stay means what? You will have to pay something. Unconditional stay you don't grant. 50% will you deposit? No? Okay. You don't have money, nothing happens. Don't seek stay. No, it's not like. No, only yes, 50%. We will grant a conditional order. It is for you to comply. On IA2 of 23, after hearing learned counsel for the parties, it is directed that in case appellant deposits 50% of the amount awarded by the commercial court, within a period of 6 weeks from today, execution of the impugned judgment and decree shall remain state till next date of hearing. Learned counsel correspondent. Case warrant is granted 3 weeks time to enable him to file objections to IA 2 of 23 as well as objections with regards to payment of court fee in this appeal by the applicant. There is past. 2 months. 2 months. 8 weeks.
Party one, we see that trouble, we take it for a time.
He is appearing. Idiot. Are they appearing? But he's appearing, right? Caveat. Notice on behalf of respondent is accepted by who? Except Pushpalata ji, who has entered appearance on behalf of respondent on caveat. Office is directed to secure the record of the commercial court. This thereafter for orders on admission.
Very the expertise. Once the board comes to a conclusion that I have proposed, but goes ahead and decides on the merit and rejects my idea or vacates the intent.
You have filed,
See on that aspect, that
you have filed,
that already presented that will be called the article of data.
right, Mr.
That's how
Once the court comes to a conclusion that it has, we did not tell you what he has told. So, ah, of course,
Here too is vacating.
no, so we will basically protect both the parties by saying that you have already filed a new suit and that court will decide without being influenced by the order which has been passed today. Fine. It will not come in the bill. Yes, it's okay for the senior counsel for the with so and so for the appellants. Mark his presence, learned counsel for respondents, learned senior counsel for respondents. Third on the question of admission. This appeal under section 13 within bracket 1A of the Commercial Courts Act 2015 has been filed by the appellant against the order dated 7/6/2023 passed by the Commercial Court, by which the Commercial Court has inter alia held that the dispute between the parties is not a commercial dispute within the meaning of section 21C of the Commercial Courts Act 2015. However, the Commercial Court has decided the application preferred by the parties for grant of injunction as well as seeking vacation of the interim order of injunction on merits paragraph. It is the paragraph. Learned senior counsel for the appellant fairly submitted that in pursuance of the aforesaid order dated 7/6/2023, the appellant has already filed a suit before which suit namely OS number 3558 of 2023, before which court? Before City Civil Court in Bangalore. Bangalore, full stop. The only contention urged by learned senior counsel on behalf of the appellant is that since the Commercial Court had already held that it had no jurisdiction to deal with the suit, the Commercial Court ought not to have decided the application for grant of injunction as well as the application seeking vacation of the order of injunction on merits. Paragraph. The aforesaid submission made on behalf of the appellant has not been fairly opposed by learned senior counsel for respondent. However, it is urged that the order which may be passed by this court shall not come. However, it is submitted that this court may clarify that the order passed today, that the City Civil Court trying the suit filed by the appellant shall decide the same without being influenced by any of the observations in the order which may be passed today. Paragraph. We have considered the rival submissions made on both sides. Full stop. It is right law that once the court comes to the conclusion that it has no jurisdiction to deal with the dispute, the court should not deal with the interlocutory applications filed by the parties. Full stop. The impugned order dated 7/6/2023 passed by the Commercial Court only insofar as it rejects the application filed by the appellant seeking grant of injunction and allowing the application filed by the respondents seeking vacation of the injunction. Seeking vacation of injunction is set aside, full stop. Even otherwise, comma, full stop. Set aside, however, it is clarified that the learned, that the city civil, learned judge of the city civil court filing OS number 358 of 3558 of 2023 shall decide the suit as well as interlocutory applications without being influenced by any of the observations contained in this order. Then return. No, as always. No, that's what I was about to say last time. Even otherwise. Last paragraph, you will last one.
Is clarified that the
No, before that, last line.
it is right law that once the court comes to the conclusion that it has no jurisdiction to deal with the dispute, the court should not deal with the interlocutory applications filed by the applicant. The impugned order dated 7/6
Interlocutory application filed by the parties, not appellant.
filed by the parties.
Hmm.
The impugned order dated 7/6/23 passed by the commercial court only insofar as it rejects application filed by the appellant seeking grant of injunction and allowing the application filed by the respondents seeking vacation of the injunction is set aside.
Set aside.
However, it is clarified that the learned judge of the city.
Before that, you write this paragraph, one line.
Yes.
Needless to state that life of an interim order is coterminous with the main proceeding. Therefore, the earlier order of injunction granted in favor of the appellant does not survive. Right, and then this line
Thanks.
clarified. Appeal is accordingly disposed of. Yes. Senior counsel appeal 7, right? After marking Mr. Fanindra's presence, requirement of service of notice on respondent number 1 is dispensed. He is admitted for hearing. Issue notice. Office is directed to secure the record of the family court.
I appear for appellants, my lords. I appear for appellants, my lords.
Yes, Mr. Potter.
Please, my lords. My lord, agreed by the judgment dated 6/4/2023 insofar as dismissing.
Your appeal is already admitted. Your appeal
Please,
is already.
Please, my lords. Please.
Not provide that after admission of the appeal, you should argue.
My
Your
lord,
appeal has already been admitted for hearing.
please, my lord.
Yes, Mr. All right. So you serve a copy on the, Mr. Ram. Yes. Mr. Gautam is Bharatwaj, Learned Counsel for the petitioner. Heard on the question of admission. Who appears for respondent number 1? Acha. Learned Counsel for the petitioner undertakes to supply a copy of the writ petition to Mr. N.K. Ramesh. Office is directed to reflect his name. Notice on behalf of respondent number 2 is accepted by learned government advocate. Respondent number, that's what we have said. How much time? Next week. Find out. $45 also. 45 he'll supply you a copy. 1 minute. We are 45. We will see to it. So what next week shall we post it or list in the next week? 45. So he will supply. You supply him a copy. counsel undertakes to, for the petition undertakes to supply copy of the petition to Mr. So and so, who accepts notice on behalf of respondent number 2. Find out what can be done, Mr. Is it, I mean, it appears to be a genuine mistake, right? That if it is possible at this point of time as a one time, we don't know. Only seek instructions to this extent, right? In any case, it has to be done by respondent number 1. Huh? Ah. All right. Yes. Representation to whom? 1. Yes. List next. Correct. That's why they are here. List next week. Basically, the action has to be taken by respondent number 1. Correct. On whatever. This is kept open, right? List next week. How? 6 is what? It does not survive. How? He said it does not survive. You didn't hear him properly. Leaving report in a hurry. Sure. Yes. Yes. The same, right? 45. 45 is also the same. All right, same order. Your objections are kept open. We are just asking you to find out what can be done. If legally it can't be done, no relief can be granted. We just want to explore the possibility. Yes. So, same order
Yes.
is supplied to Mr. Ramesh and office director to check his name, and then you have the copy. List next week. Same order. Well, okay. All right, learned additional government advocate, write her name, learned additional government advocate accepts notice on behalf of respondents 4 to 36. Therefore, the office objection is ignored. What is dispensation, Mr.? You also don't know. Yes. Not for the petition. Yes, madam. Right. Learned, your government advocate, right? Learned additional government advocate submits that the service report has already been filed on what date? 13 June 2023. The office objection is therefore ignored. Learned additional government advocate further submits that the compliance affidavit has been filed on 13th April 23. Awaiting the appearance of learned counsel for the petitioner, hearing is deferred. List after 1 week. When date? Why it is this thing compliance affidavit? Why it is none for the appearance behalf of learned counsel? When have you filed police? None for the petitioner. Additional government that submits that Police report has been filed on June 23. In appearance on behalf. Hearing is deferred. List after one.
Okay, the KB Nand Kumar.
For the petitioner. List after 1 week. Okay. When you are on that says you are fine. All right. The counsel for the petitioner prays for adjournment. Let's start. Will come. Which case? Item 7. Yes, madam, what office of like let office objection be within 1 week list thereafter. Okay. And for the petitioner office objection be complied with within 1 week. Right? Right? You have complied, not what time. The counsel for the petitioner prays for and is granted a week's time to enable him to produce the endorsements which have been received by him. The additional government advocate undertakes to supply a copy of compliance affidavit. Learned counsel. Adjournment to enable him to go to the same. Just after 1. Day after tomorrow. Even eligible. Yes, review of submission made by the counsel for the petitioner, the office objection is ignored.
Appear for respond number 1, madam.
The counsel for the petitioner prays for and is granted a week's able him to pay process fee. List or as prayed list for analogous hearing along with WA number of 22. What? Who appear corresponding? Petitioner, you are appearing. What? Awaiting service.
General of course, Tamil Nadu was directed.
Tamil Nadu. Current counsel for the petitioner submit that he has taken out hand summons for service of notice on this content and has filed an affidavit today. Let the petition be listed in next week. But okay. Affidavit has been filed. Next week. Let the contempt petition be listed in the court of law. What we are supposed to take only urgent matter. It's not urgent. Next week, what did you? All right, we are not hearing this petition and fixing a date. 5th July. 5th July. No, you inform sub-register. Huh? The counsel for the petitioner submits that intimation about the order dated 25/10/2022 passed by commercial court. The arbitration appeal A number 508/2022 was furnished to respondent number 3, wide annexure C, and despite the aforesaid order, despite the intimation, the respondent number 3 has violated the order passed by the commercial court, and therefore he has been impleaded as the respondent in this contempt petition. Accused as an accused in the contempt petition. So stop in view of a process submission of this objection will be given. Time, madam. Have to file compliance report. Yes, Krishna. Learn it counsel for 2 weeks for sir. 2 weeks time to enable him to file compliance. Why have you taken these people? Take the position. If a company is a party, you can implead director. Examine this issue. In this issue, there is a decision of Supreme Court on this, right? Learn it counsel. Learn it. Learn it counsel for the 2 weeks time to enable him to address this court in the light of on the office objection. Require a direction to it. Direction 2 and 3. There's no direction to him. How can be held liable? Correct, but there's no direction, right? How can he be held liable? Therefore, you have to impede him with the leave of the court. That's all you can do. We understand, right? But you may be right in contending that in order to effectively ensure adjudication on like payment and to see that it is complied with his presence is necessary. But that is not, this is not a writ petition, contempt. You impede him with the leave of the court by moving an application, right? Learned counsel for the petitioner undertakes to delete the name of appellant number, accused number 1 with the liberty to file an application seeking his impleadment. Accordingly, the office objection is that there let necessary correction be made within 1 week. 1 week. How much time? That's what we are asking. Counsel for additional learned counsel for additional government advocate. Based on his work. File an affidavit of compliance. This time, same order. Appliance report or reply. Alright, so compliance reports stroke reply. Stop. If objection, translated copy. Great counsel for the petitioner submits that the requirement of filing a translated copy of annexure F5 be dispensed with, as he would not place reliance on the aforesaid eviction. In view of aforesaid submission, office objection is ignored. Let the petition be listed for orders on admission. Admission, it's not today. It will be listed, right? Next week, no urgency, Mr. Next week. Who appears? RD presence, heard learned counsel parties on IA1 of 2022 for the reasons assigned in the application form. It is supported by an affidavit form. We find that sufficient cause for fundamental delay of 8 days in filing the appeal is made up. The delay in filing the appeal is continued. IA is allowed. IA1 of 22 is allowed. Let the appeal be listed for orders on admission and for consideration of IA2 of 22 in the next week. After green bench. So if it's urgent, then we can post it tomorrow or day after, whenever. It's extremely urgent. We can't. Tomorrow. Huh? Articles, learned senior counsel for the petitioner, Mr. S. S. Mahindra, learned additional government advocate list. In view of urgency, it is by learned senior counsel for the petitioner, let the direct petition be listed for orders on admission and consideration of prayer for interim relief tomorrow. Nothing survives, right? Nothing survives on the occasion of silver jubilee of this case. What remand? 24 years. Ah. Arey, what, Mr. 24 years? What 1 week? Finally, he granted. Canara Bank. They have said the matter is remanded to the division bench. We request the division bench to dispose of the matter as early as possible. We have perused the record. Honorable Supreme Court order dated 19th April 2023 has remitted the matter. It is remitted the matter for adjudication afresh and has requested to dispose of the matter as early as possible. Learn it. You are not government advocate. You learn it a additional government advocate, a high court government leader. Why you are praying for time? Why judgment? What else? Whatever. Then High Court government leader. However, prays for adjournment on the grounds that the file has not been traced out. Go of opposite submission by way of indulgence hearing is deferred. It may clear that no further adjournment shall be granted. Just on 4th July 23, Tuesday.
Inform counsel for responding. Also inform counsel for responding about this order.
If not come, otherwise they will say the same thing on court. That though you have copy, we don't have. But judgment shall be granted to learned additional government act, right? You can see it here. Sir, 38. Did FIR? Arjun? Sir, just now we called final hearing. We came across a case which is pending for 24 years. By these standards, we should be very liberal in granting adjournment of another 5 years. Now, how many? 4 or 3, 7 years. You are competing with him, right? 24 years. If we count it up, today is what day? Friday? Today? Huh? No, no. We are asking you, what is the day of this week? Today. Monday, right? Monday. No? Looks like Friday. Huh? Surprise. No? Let him come. He will. Otherwise, he will say that violation of principles of natural justice. Please wait. Take it up. Too much. Which case? Same 50 pass over, the 51. You show his name. He's here. Okay. Yes. From this side. You are standing behind the monitor, so yes. What happened? Round. Round. Which ground you had filed a petition? Why your petition has been dismissed?
Two children. Two children from the marriage. Staying with whom? Staying with whom? Mother.
What he argued? 16 years living together. Eight. And date of birth of children. Huh? Sons. When did you, according to him, when did you leave the matrimonial home? What date? Just filed the petition. Mister, we are surprised you look at us as if we are speaking German, right? Huh? We are speaking English only, right? Petition has been, no. petition has been filed by the appellant on the ground of desertion, correct? So what is required to be proved in desertion? What is the requirement? He has not argued. He has only said 14 hours living, 14 years living separately. Therefore, that's his argument. So we can't write like this, judgment like this. Living separately for 17 years is not a ground for dissolution of marriage. You know, right? He has to prove. So we are asking, what is the law? What is the ground which is required to be proved? Desertion, how it is? Not negligence. When did you leave the matrimonial home? Petition. When? What is said in the petition? Nothing. You told Mr. Hegde, Mister, did you tell Mr. Hegde? What is it? Yeah. Read the evidence of the applicant and your statement. Evidence and your evidence. His evidence also, he has not read anything. He will have to write a journal. As he said, I mean, read means not only my father's name is like this. Don't see where he has said anything about desertion. Will you read that portion?
subject.
You said. That's what you said.
Just a second. Your cross-examination, you have said that the husband has married a girl from Tamil Nadu. That's your contention. Cross-examination.
We continue after the break. After the break.
If that is the fact, just think over. If that is the fact, you are saying that he has married second. How can yes,
Submit counsel for the applicant submits that the arguing counsel is not available on account of personal difficulty. List in next week. What? Which case? So make it tomorrow, then what prevents you? Which case?
Senior advocate Jaikumar S. Patil has appeared in that matter. He's saying that matter is listed tomorrow along with
Which
the
case? We don't know this. You have to move what? Which case is to be listed? What case? To make a mention tomorrow, we will see what, not at this. Yes, Mr. 51. Nothing to worry about. Lord has been told to by way of abundant fortune. You should feel concerned. Yes. So, yes. Does it mean? Does it mean by the reading?
All right. You read
What
only
is-
relevant portion, then
What does
what
it-
transpires from that? All right. What according to you is the reason for separation? Very significant. It is not established. Yes, denied. Yes, denied. Yes. Next. Just page, which page?
Case 50. Transaction 50.
Here is. See, having filed the petition seeking dissolution of marriage, you have put a suggestion stating that you are willing to stay with the wife. This is your suggestion. In the cross-examination of wife, you have put a suggestion stating that you are willing to stay with the wife. Court has rightly dismissed it. Stay with the wife. As simple as this. This is one suggestion. Further, one more suggestion is, her parents are not allowing her to stay with you. That is one of the suggestions. So these two suggestions, one is parents are not permitting. Second thing is he is willing.
She is not.
Sure, that is the stand. The stand is not established. You are disputed it. Second marriage is not established. And maintenance is granted in favor of the wife. So that means she has not left your company without any reasonable cause. That is the case. Her petition seeking maintenance would have been dismissed. The court is confirmed by this court. Cruelty are not needed at all. Not a ground of.
The same thing.
That's all. Challenging the making of the family court set, challenging the judgmental decree. Asking MCT number 378 on the file of 378 of 2014 on the file of family court that much. In terms of the interim judgment and decree dated 7th January 2017. The family court has dismissed the petition filed by the husband seeking dissolution of marriage on the ground of desertion. Additional proceedings are referred to as husband and wife. three facts necessary for adjudication of the case can be summarized as under. The marriage of the parties was solemnized on 4/4/2002 at Vidyaranyapuram, Mysore. Admittedly, there are two children from the marriage. The first child was born in the year 2004. Second child was born in the year 2006. It's stated by the petition that marital life was pleasant initially and later the dispute started between the parties. But further state that on 22/8/2007, on the fourth birthday of the first son, there was a quarrel between the 22/8/2007, the parents of the respondent who visited the house of the husband raised a quarrel without there being any cause, and the wife went with her parents to her maternal home by taking all the gold ornaments as well as his 4 lakhs cash belonging to the husband. Further stated that the wife did not return to the house of the husband, and in the 2014, the husband issued a notice to the respondent, calling upon the respondent. Notice was issued asking her to come back, calling upon the respondent to join his company. He further stated that the wife issued reply notice making false allegations against the husband, and thereafter the husband has issued a rejoinder to the said reply notice, and he was constrained to file a petition seeking dissolution of marriage in the premise. The wife has deserted the company of the husband, and he has sought dissolution of marriage on the ground of desertion. The respondent appeared and filed a statement of objection contesting the allegations leveled against her. The relationship is admitted, and the fact that the two children are born from the marriage is also admitted. However, the wife has taken a stand that the husband is to insist her father to give money on the premise that the husband is in a financial sound position and he has incurred loan to run his business. So it's also a contention that despite the husband despite her father having assisted the husband financially, the husband is not satisfied with the financial assistance provided by the father. It's also continued by the wife that when her sister was married, the site was given to her sister at the time of her marriage, and the husband started insisting her father to give a similar site to him, and since the demand was not exceeded, the husband threw away the wife and the children from his house, and he is constrained to live separately on account of ill treatment given by the husband. Accordingly, she has prayed for dismissal of the petition. Before the family court, the husband is examined as PW1. Documents are marked with exhibit P1 to P6. Wife is examined as RW1. The 20 documents are marked as exhibit R1 to R20. After hearing both the parties, the trial court, the family court has dismissed the petition on the premise that the plea of possession is not established. Secured by the aforementioned statement and decree, the husband is in appeal. Next one. Third, the learned counsel appearing for the husband as well as the learned counsel appearing for the respondent. Next one. The learned counsel appearing for the husband would submit that the plea of possession is duly established. The wife in the cross-examination has admitted that she is not willing to join the company of the husband, and despite notice being given to the wife in the 2014, that is 7 years after the separation, the wife has not come forward to live with the husband. And accordingly, the family court also have granted a decree for dissolution of marriage. Also, his contention that wife has not allowed him to meet his children 7 years after she left the house of the husband. And this would clearly indicate that wife has no intention to come back from the company of the husband. And they would further submit that the family court has not appreciated the pleading and evidence based on the court in a proper perspective and erroneously rejected the petition seeking resolution of marriage. Current counsel is hearing for the respondent would submit that the plea of desertion is not properly pleaded. The evidence is not led to the fact that the wife has deserted the company of the husband with an intention to put a permanent end to the marital relationship. Also, his case that it is established from evidence that the wife was harassed on the pretext that wife was harassed on the ground that her father is not providing proper financial assistance to the husband who is in financial difficulty. And it is also her case that since a site is given to her sister who is married after the marriage of the respondent, the husband started harassing the respondent, the husband started harassing the wife and her parents to give a site to him. Since the demand was not met, he has driven the children away from his house, and he has not bothered to maintain the wife and the children. And accordingly, the wife has filed a petition seeking the maintenance for herself as well as her children, and same is granted by the jurisdictional court. And accordingly, we would submit that the plea of desertion is not established and the plea for dismissal of the petition. This court has considered the contentions raised at the bar and also produced the pleading and evidence on record. Relating to decree for dissolution of marriage on the ground of desertion is well settled. It has to be pleaded, established evidence that wife or the spouse has left the company of the spouse with an intention to put a permanent end to the marital relationship. On perusal of the pleading, it is forthcoming that no such plea is raised in the pleading. Even the evidence of the husband is not sufficient enough to accept the intention of the husband relating to the desertion. It is forthcoming from the cross-examination that the husband has put a suggestion to the wife that the wife is prevented from joining the company of the husband by her parents. This itself would indicate the fact that the husband is not leveling any allegation against the wife that she has an intention to put a permanent into the relationship. It's also forthcoming from the record. It is an admitted fact that the petition filed by the wife seeking maintenance for herself as well as her children is allowed to stop, and that order is said to be confirmed by this court. It is apparent that when a petition under section 125 is filed, the wife has to establish, the person seeking maintenance has to establish that the person is staying away without there being any reasonable cause. Since that petition seeking maintenance is allowed by the jurisdictional court, this court has to conclude that the husband has failed to establish the fact that wife is staying away without there being any reasonable cause, with an intention to put a permanent into the marital relationship. It's also forthcoming from the record that the husband has not made any attempt to seek the custody of his children. It is also admitted in the cross-examination that in the past 7 years prior to the cross-examination, he has not met his children. You can notice that he has not filed a petition seeking custody right or visitation rights. Under these circumstances, the court can certainly draw a conclusion that the husband has not shown any interest in the welfare of the children as well as interest in the wife. Under these circumstances, the contention of the wife that the husband has given away the wife and the children away from his house appears to be more probable. Under these circumstances, the wife staying away from the husband cannot be construed as an act of desertion so as to grant a decree for dissolution of marriage on the ground of desertion in favor of the husband. The trial court has also considered the evidence on record, and after analyzing the evidence on record, the trial court has concluded that the husband has leveled false allegations against the wife, stating that wife has stolen rupees 4 lakhs to the husband, and the trial court has also, family court has also concluded that the claim of the husband that he paid rupees 3.25 lakhs for the treatment of wife's father is also incorrect. After analyzing the evidence, after analyzing the entire evidence on record, the family court has come to the conclusion that the plea of desertion alleged by the husband is not established, and has deemed it appropriate to dismiss the petition seeking dissolution of marriage. This court has produced the reasons assigned by the family court. This court does not find any infirmity in the judgment and decree passed by the family court in dismissing the petition seeking dissolution of marriage. For the aforementioned reason, the judgment and decree passed by the family court at Mysore, mention number 378 of 2015, dated 7th January 2017, is confirmed accordingly the appeal is dismissed.
What's the ground? Which item number? Yes, Mr. Preventive detention. That what? The ground this time. Cases. In item 100, you are under detention. Huh? You are already in custody. Order. So, ask. Mr. He was in custody, correct? So are you aware? You aware about the fact that he was in custody? Have you formed any opinion that how can he? What is that case law, Mr. Taylor? If a person is in custody, (36) para 13. What are the offenses? Oh. You are a habitual offender. Huh? Mr. Para 13, page 48. Up to no. a compilation which has been given to you. Come to page 48, para 13. So if that is complied with, fine. Otherwise, you know what happens. Hey, what tomorrow? Hey, what is a case law? You know it, right? What? No, that's what Supreme Court also says. See para 13. Read it. Correct. So from that order of detention, you have to tell us that you knew that he is already in jail, in custody. Secondly, you had reason to believe that he can be granted bail. And thirdly, you had to form an opinion that if he is released on bail, he would again indulge in a privilege. That you show us from the order of detention. For that, no case law. We don't think that this legal position has changed. What is the latest decision? What is citation? What is the citation in 2019? What have we seen? Oh. So what is 2019 citation? You tell us. From order of detention, you have to point out. Simple, happy, Dhakar, right? Huh? So, Mr. We have already passed an order. 2019 SCC on line 7875. Correct? Mr. Agree. So this submission is, two grounds. Delay in deciding the representation that we may not go into. What he says that he was already in custody when you passed an order of detention, right? You can detain him in custody provided these circumstances are satisfied. In para 13, page 48. He will show you. Please go through it. No, then what tomorrow? This is what it is. Point out from the order of detention. So, Mr. You instead of we will tell you that you should be conscious that he is already in custody. Number two, you have to form an opinion that he is likely to be released on bail. Thirdly, you have to form an opinion if released on bail, he will again indulge in the activities which are chose from the order of detention. Have you formed an opinion like this? Then end of the matter. Ah. You aware that he's already in custody? And there is a likelihood of, where is it, Mr. Order of detention? Which para? Which page? Ah. Page. Ah, yes. Yes. Come to page 35. Are there cases against you? Fine. We have read it. That's why we told you. Is there a case against you under NDPS Act? Fine. What else apart from that? No, who says 27 days is not an ordinary delay? Oh, correct. Tenth February. Ah. What did you do, Mr. 10th of February?
Delay. Inordinate delay. It's not inordinate delay. Maybe inordinate delay. This.
What? That's correct. But you tell us, have you said something about what did you do from 10th of February till 9th March?
Yes, please.
Yes, please. Anything else? No, so the only thing is that they should be aware and they should form an opinion. That they have done is read of NDPS Act. Fine. Synopsis which was given by you. Right. Got it. Yes. No, but you jumped the bail in one case, correct? Violated. That's it. Yes. All right, please sit. You have argued it very well, prepared it. That's how it should be. This is exactly the time it should take. Right. Thank you. You have prepared very well. Yes. In this, see, we allowed the petition dismissed. That's a different thing. But we want to say that you have prepared very well. And we are dismissing it only on the ground that NDPS. To tell you honestly, not that we will assign reasons. That's a different thing. All right. In this petition, you are what? She's the mother. In this petition, the Article 226 of the Constitution of India, petitioner who is the mother of the detainee. What's your name? Detainee mainly Sagar has assailed the validity of the order of detention dated 29/9/2022, as well as the order dated 6/10/2022. 6/10/2022. Under the provisions of Karnataka Prevention Right Whole Thing Act. Referred to as the act for short, right? The petitioner that's leading to filing of the detainee. The detainee was arrested on. Okay. He was arrested on 1st of September 2022 by which police station? Yeah. Girinagar Police Station. Girinagar Police Station in connection with offences in connection with crime number 53 of for offences under section. Admittedly, or 7 other cases. Total you said 8, no? How many cases? Admittedly, 7 other cases are pending against the detainee. The details of the criminal cases pending against the tenure or as under. Report was submitted to Commissioner of Police, whereupon an order of detention under section 3(1) of the Act was passed on 29/9/2022. To stop the aforesaid order was forwarded by Commissioner of Police to Commissioner of Police Bangalore to the state government for confirmation. The state government by an order dated 6/10/2022 passed under section 3(3) of the Act confirmed the order passed by the Commissioner of Police. Full stop. The advisory board on 2/1/2022 recommended that there are sufficient grounds for detention of the detainee under the Act. Full stop. Thereafter, by an order dated 5/11/2022, the state government confirmed the detention of the detainee, detention of the son of the petitioner under section 13 of the Act. The detainee submitted a representation on 10/2/2023 to the state government. Was received by the state government on 13/2/2023. Full stop. So, yes, the representation was rejected by an order dated what date? 9/3/2023. Full stop. The mother, the petitioner filed this writ petition on 7/3. On 7/3, the mother of the detainee filed a petition. The petitioner filed this petition on 7/3/2023. Right after, thereafter, this representation was rejected. Next line would come there after this. 7th March. The 9th rejected, right? Paragraph. In the opposite factual background, this petition has been filed. Merit counsel for the detainee, merit counsel for the petitioner has merit counsel for the petitioner has submitted that has assailed the validity of order of detention on following two grounds. Number one, there is a delay in considering the representation of the detainee which vitiates the order of detention. Number two, that the appellant, that the detainee was already in custody when the order of detention was passed, and the satisfaction that detainee is likely to be released from jail is based on no material, and therefore the order of detention is liable to be questioned. The other hand, learned counsel for learned SPP2 has submitted that the detaining authority, that there is no unreasonable delay in deciding the representation of the detainee which vitiates the order of detention. It is also urged that the detaining authority was conscious of the fact that the detainee was in custody and had formed an opinion that he is likely to be released on bail and shall engage himself in the activities prejudicial to the public order. So, his submission petitioner, right, inordinate delay in support of appropriate submission, reliance has been placed on, right. These decisions number 2 and 3, right. We have considered, you have the record. It means when. We have considered the submissions made on both sides and paragraph. The detainee the detainee had submitted a representation. Detainee had submitted a representation on 10/2/2023, which was received by the state government on 13/2/2023. The opposite representation was decided by an order dated 9th of March 2023. The question of delay in deciding the representation has to be determined in the facts and circumstances of the case. In the facts of this case, in our considered opinion, there was no delay in deciding. There was no such delay. There was no such delay in deciding the representation which would vitiate the order of detention. Therefore, the contention that on account of delay in deciding the representation submitted by the petitioner, by the detainee, the order of detention is vitiated, does not deserve representation, does not deserve acceptance. Paragraph. The Honorable Supreme Court in Dimple Happy. Dimple Happy. Union of India and another. Union of India and another versus Dimple Happy Thakur. 2019 SCC on line 875 has held that even if while reiterating the decision, while reiterating the principles laid down by it in Kamrun Misa versus Union of India 1991 SCC 128 has held that even if a detainee is in custody, an order of detention can be passed provided the detaining authority is satisfied that if the detainee is released from the custody, he is likely to indulge in activities which are prejudicial to the maintenance of the order. Full stop. From perusal of paragraph, from the perusal of order of detention, it is evident that the detaining authority was conscious of the fact that the detainee was in custody and the nature of activities of the detainee indicate that if he is released on bail, he is likely to indulge in activities which are prejudicial to the maintenance of public order. Thus, the opposite detention has been recorded by the detaining authority. Therefore, the contention that by the detainee that since he was in custody and therefore the order of detention could not have been passed does not deserve acceptance. For the aforementioned reasons. No, see, somewhere it should come. Which case, Mr. You were in custody? Admittedly, somewhere you write after Dimple. Admittedly, the detainee at the time of passing of the order of detention was in custody in connection with crime number 253 of 2022 for offences under section. Same thing, right? You told us in the beginning, right? Of the aforementioned reason. In our considered opinion, the order of detention, which has been affirmed by the state government, does not suffer from any procedural infirmity warranting interference of this court in exercise of powers under India. Aforementioned reasons, the petition fails and will be heard by the. What is the about other case? For NDPS. Where is that? Give it. Mr. Ready? Take. It should be fair. Yes. 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 It's petition. Petition under Article 226 of the Constitution of India. In fight. So in this petition, she is the mother. Wife. The petitioner, who is the wife of the detainee, has filed this petition assailing the validity of the order of detention dated 2/2/2023, passed under section 3(1) of the whole thing act, correct, as well as validity of the order dated 10/2/2023, passed by the state government under section 3(3) the act. 3 of the act. Passed of validity of the order dated 10/2/2013, right? 10/2/2013, not 3(3). 10/2/2013, passed under section 3(3) of the act. The petitioner has also assailed the validity of the order dated 3/3/2023, passed under section 13 of the act. Facts giving rise to filing. How many cases? All right. Facts giving rise to filing of this petition. Stated that the petitioner is the mother of the wife of the detainee. The detainee was arrested on oh. All right. When were you detained? That's what we are. All right, the detainee was. All right, the detainee was arrested on 3rd of February 2023. 2nd February. 3rd February 2023. By which police station? I could. Huh? All right. So when were you arrested? Till that. So when were you? Delete this. Admittedly, the detainee was in custody in connection with crime number 253 of 2022. 2022. Full stop. Bench of this court by an order passed on 1/2/2023 granted bail to the detainee. However, before the detainee could be released on bail, Commissioner of Police passed an order under section 3 within bracket 1 of the Act. The copy of the said order was forwarded to the state government for confirmation on 3/2/2023 Thereupon, an order on 10th of February 23 was passed under section 3(3) of the Act. Thereafter, when 13 order was passed, paragraph. Paragraph. Thereafter, the detainee submitted a representation to the advisory board, which was received by the state government on 17/2/2023. The advisory board in its report dated 23/2/2023 recommended that there are sufficient grounds for detention of the detainee under the Act. The state government, by an order dated 28/2/2023, rejected the representation submitted by the detainee. Thereafter, an order was passed by the state government under section 13 of the Act. 13 of the Act, paragraph. The detainee thereafter submitted another representation on 17/3/2023, which was rejected by the state government by an order dated 28/3/2023. In the aforesaid factual background, this petition has been filed. Paragraph. But counsel for the has submitted that there was inordinate and unexplained delay in considering the first representation dated 17th February 2023 and second representation dated 17/3/2023. It is further submitted that delay in deciding the representation has initiated the order of detention. Full stop. It is also urged that the while inviting the attention of this court to paragraphs 5, 7, 8, and 9 of the representation dated 15/2/2023, the petitioner has submitted that it is submitted that the detainee had sought for the documents. However, the copy of the documents was not supplied to the detainee, and therefore he was deprived of his right to make an effective representation against the order of detention. It is therefore urged that that failure to supply the documents has violated a fundamental right guaranteed to the detainee under Article 22(5) of the Constitution of India. To stop. On the other hand, learned SPP has supported the order of detention passed Commissioner of Police, which has been affirmed by the State Court. Paragraph. We have considered these submissions made by learned counsel for the parties and have. Where is that, Mr. Judgment? Page 82. Which para? Honorable Supreme Court in state of Manipur and others versus page 80. 2020-22 SCC online SC 1455 in para 70 as held as under, right? Para 17 and 18 has held as under, right? In the backdrop of aforesaid well-settled legal principle, we may advert to the facts of the case in hand. In the representation dated 15/2/2023, the detainee had sought for the documents on the basis of which order of detention was passed. However, the aforesaid documents were not supplied to the detainee, and the representation submitted by the detainee rejected by an order dated 28/2/2023. Thus, it is evident that the that the that the detainee has been deprived of his right to make an effective representation, and therefore the action of the respondents in not supplying the documents to the detainee to enable him to make an effective representation amounts to violation of Article 22 within bracket 5 of the Constitution of India. Full stop. Paragraph for the aforementioned reasons. Order of detention so and so affirmed by so and so, as well as order under section, as well as order dated 3/3/2023, passed under section 13 of the Act are hereby quashed. The detainee be set at liberty if not required in connection with any other case. In the result, petition is allowed. You give another set. No, you have one. Citation. So, Mr. You look at the case very well. Now, see, if you want the case to be heard early, you should be prepared like this. Thank you, Mr. Hegde. Yes. Okay.
They appear for the appellant, my lord. But I'm ready, my lord. May I place the facts, my lord?
Why not? She is also ready. You are ready, no? We are telling him that you are ready and you are saying that in senior counsel. He is on his. 6 years, madam. You understand, right? What is it? Why they have filed an appeal? At least tell us. We not they have filed. You are respondent, right? Why they have filed an appeal? Has learned single judge done? Right. When do you want? Yes, Mr. They are praying for adjournment. Who is not available, madam? Who is
Then
not
on
available?
Friday.
Senior counsel.
Lord, then could it be on Friday, please, my lord? I'll also
Okay.
appear physically, my lord. Friday, my lord, please. 30th, my lord.
Yeah. No, not 30th. Any other date.
Then 6th, please, my lord. 6th or 7th, my lord.
That's what she is saying. 6th July.
6th, please.
Third counsel correspondent prays for adjournment on the ground that the arguing counsel is not available on But he had appeared, he argued the case before us today, Mr. Aranali. Right? He is not available at this point of time. List. See therefore praise for adjournment. List on 6th of July 23. Sir, 53, 15 Edgardo, the Rupert Kumar is what, like it was fought on the ground of desertion. Well, so you are the husband. Why? The husband's petition has been allowed. Wife and you have dismissed. Oh. Then also you failed. You are not cross-examined. That's fine. On 16/9/2014. Yeah, the
Wilton does, he has also alleged marriage is void on the premise that he was minor. That is not all about.
He should have been believed, I guess. Yeah, since many cross-exam.
There is no challenge for the family court, there is no challenge for this court.
The other side does not appear. End of it. That's what are you arguing? Yes. What is this thing you show us from petition? What have you said about cruelty and your statement? Allegations of cruelty. Only relevant parameters. Don't read everything. Cruelty thing you read whatever. What she has said about cruelty. What did he do? Yeah.
Family court has not referred to anything about that. It only says the petition is liable to be dismissed because there is a majority. The point of weight has not discussed anything. Just going to
So what are the governments of cruelty, Mr.? Ah, that is said in your examination in chief. Same paragraph. Third copy paste.
section 12. She was age 15 at the time of marriage. And she got that section deleted.
Yes.
Petitioner in MC 353 of 2015 on the file of family court at Mysore, first additional family court at Mysore. Is impugning the judgment and decree dated 27th March 2017. What is to the proceeding are referred to as husband and wife. Stop. The wife filed a petition, section 13, 1A of Hindu Marriage Act, alleging cruelty against the husband. Full stop. The marriage was solemnized on 8/6/2009 at Mysore. Full stop. It is her case that the husband and wife lived together only for 2 months, and even that period of 2 months, there was quarrel between the husband and wife. And despite the best efforts made by the elders, the normal marital relationship not take place. It's our contention that the husband used to drink alcohol every day and used to abuse the wife and defame her by in the presence of others. It was also alleged that the attitude of the husband is also not a good estimation of the public, and it is further submitted that she was not treated with respect, and does not have the adjusting. It is not having adjusting nature. It is further stated that proposed to marry against their consent, and there used to be a frequent quarrel over petty matters. Alleging these facts, the petitioner is filed on the premise that the marriage has dissolved. He appeared and contested, or he made expert. Filed objection. Respondent may has not filed objection. Yes. Respondent, the husband appeared before the court. However, he did not file statement of objection. Thereafter, the wife has led evidence. She has reiterated the government's made in the petition relating to the alleged act of cruelty on the part of the husband, and she has stated that it is not possible for her to lead marital life with the respondent, and as such, wait for decree for dissolution of marriage. Full stop. The respondent has not cross-examined the petitioner. The petitioner, in support of her contention, has produced 6 documents marked Exhibit P1 to P6. One of the documents is the mask card, Aadhaar card, SLC mask card of the wife, and it is evident that she was born on Ten 12/1994. It is evident that she was aged 15 at the time of marriage. Full stop. However, the family court did not consider the case of the petitioner under Section 12, as the Section 12, which was earlier invoked, was deleted by way of an amendment. Full stop. However, it is to be noticed from the interim judgment and decree that the family court has not considered the case of the petitioner, wherein the petitioner has made out a case for dissolution of marriage on the ground of cruelty. Stop. Next point. Notice that current counsel appearing for the husband would submit that the evidence of the wife relating to cruelty is not contested and it has remained unchallenged. As such, family court is not justified in dismissing the petition seeking dissolution of marriage. Stop. We further submit that the plea of cruelty is very much established, and husband and wife live together only for 2 months after marriage, and in that period of 2 months, the relationship of the husband and wife was not cordial, and the husband used to abuse and insult the wife under the influence of alcohol, and this fact has been duly established, and that the evidence led by the petitioner is not challenged by cross-examining the petitioner, cross-examining the wife. Next one. We have considered the contentions raised at the bar and also considered the contention. Also, there is the records claim for the court and also the interim judgment and the decree. Effect of not cross-examining. Para number 8. Respondent, page number 7. Keeping in mind the aforementioned principle, this court has to contest whether the wife has made out the case for dissolution of marriage on the ground of cruelty. As already noticed, there is no cross-examination and there is no objection filed by the husband to the petition filed by the wife. When there is no challenge to the claim made in the petition, as well as when there is no challenge to the evidence led by the wife, this court is of the view that the family court erred in rejecting the petition. It is also required to be noticed that the family court has not adverted its attention to the evidence led by the petitioner relating to the cruelty. The family court has proceeded to dismiss the petition on the ground that the petition is not filed under Section 12 of the Hindu Marriage Act, and the petitioner has filed the petition years after marriage. Having noticed the fact that there is no challenge to the cross-examination, there is no challenge to the evidence led by the petitioner, and there is no challenge to the petition filed by the wife has established her plea of cruelty, and she is entitled to the decree for dissolution of marriage. For the aforementioned reason, this could be the view that judgment and decree passed by the family court, which is under challenge, has to be set aside. Accordingly, same is set aside. The petition seeking dissolution of marriage, the section 13(1) of Indian Marriage Act, MC number 353 of 2015 in the file of Family Court Mysore is allowed. Subsequently, the marriage solemnized on 3/6/2009 in the appellant and respondent is resolved. Permit the police. Paragraph. One sentence. Sir. There was no representation on the respondent.
Before the way to work ready. Some. Yeah. At that point of enjoy.
But her petition has been allowed. On ground.
So I did not find out a job there. And it was only, and I was always thinking my job and feeling back to all and all again.
I found him. So what was she doing? Is she an engineer? So what have you to say on the quantum? Apart from this stage that you say that it could have been passed at the time of decree. What do you do? What is your income? What do you do? But you are also an engineer.
She is not married now. She is not married now.
Lakhs is a reasonable sum, right? Lakhs is a reasonable sum. See, Mister, even if she is employed, she is entitled to maintain herself in accordance with your fact that she is earning, that doesn't disentitle her to claim maintenance. If you are, like you had a salary of 1 lakh per month. We understand. So you are like any children born from the what's your income right now? What's your income? So who represents the respondent? How much time? By 2 weeks, he's in Bangalore, right? You communicate later, not by. What does it matter? You tell her, file it within a week. It's from Bangalore, right? In view of law laid down in Rajneesh versus Neha. Learning counsel for the applicant pays for a short accommodation to enable him to file an affidavit indicating his assets and liabilities. Paragraph. Though none has appeared on behalf of the respondent, or not say though, none has appeared on behalf of the respondent. Respondent shall also file an affidavit with regard to her assets and liabilities on or before next date of hearing. List after 1 week. About 55, the N average of what it? Tell us jointly. Tell it, Dave. Then, 5th July. That's why we said you fix a date. And July is not a Sunday, right? Not a Sunday. A Monday. Just by a narrow margin. The presence. When it comes for the applicant pays for short accommodation to enable him to place on record certain documents. List on 10th of July 23. Whatever time, madam, we don't know what will be the, it can be 11th, whatever time it comes, we don't know. Yes. 56, yes, madam. Already. Go ahead. What is it? To argue without any hesitation, there's nobody to oppose you, right? Yes. What about this judgment and decree? Your petition has been dismissed. Also, you have to challenge that order also, that part of judgment also. Which so what is your ground of challenge? What ground he had sought this thing? On the ground of desertion and cruelty. When, so like when was the marriage performed? When were the children born? This twin. Well, 2010. All right. Then what happened? What, according to respondent, when did you leave the matrimonial home? Very. You left the matrimonial home. And when was the petition filed? The husband's petition. Did he send any notice to you after you deserted, like you left the matrimonial home? Did he send any notice to you? Nothing. He filed a petition. So he has sought resolution on the ground of what are the averments with regard to cruelty. What was your defense? Yeah, forget about that. We will come to this. What did you say that when he said that 17 January 2011 you have left the matrimonial home? What did you say in your statement of objection? In your case, you did not desert him. The finding. You have to read it, madam. Read. Which page? Page number. Zero three. Fine, but why it has been allowed?
Why the petition is allowed? What ground? Why the petition is allowed? What is the finding of the family court?
This, you will have to read it, madam, from the judgment. Please read.
Cruelty as well as desertion. But this petition is allowed not just on the ground of desertion. The court has also upheld the ground of cruelty. You have lodged a complaint against the husband and his mother, right? Or his family members. What happened to that complaint? You filed complaint alleging what? His passport was impounded on your complaint, based on your complaint. That's understood. What is the allegation leveled against the husband and his family members in the complaint? What is the allegation leveled against the husband and his family members in the complaint filed by you? The court has given a finding that the complaint is a false complaint, making false allegations against the husband and his family members. Understood. See, now you have produced an additional document to say that he is married and he has got a daughter from the second marriage. Do you also still pursue your petition under Section 9? You filed a petition seeking restitution of conjugal right. Now you have produced a document to show that he is married and he has got a daughter from the second marriage. You want to still press your petition under Section 9? You want to join him? Or are you only focusing on alimony? It is understood. It is understood. In case your petition is allowed, seeking restitution of conjugal right. And if his petition seeking dissolution of marriage is dismissed, what will be the consequence? Are you ready to join the husband? You say that there is a daughter from the second wife and there is already a second wife. What are your instructions?
Tomorrow,
Seek instructions.
tomorrow you tell us. Tomorrow you tell. Yes. Only quantum of maintenance matter. How much has been granted? How much? How much has been granted? No amount. All right. What is your claim? What do you do? The respondent has also filed, husband has also filed an affidavit. It has been filed. Or affidavit.
Just find the asset and liability statement. This is qualification. Any movable property in his name? Any immovable property in his name, husband's name?
You are a senior manager in IBM. What's your salary? Where have you said in your affidavit? Affidavit disclosing.
How old are they? Daughters?
Yes. So what is your claim for maintenance? How much?
How much you claim? So what according to you is the reasonable sum in this case? No, according to you, what is the reasonable sum?
Maybe should, right? If you
Yes.
It is split. Split.
Yes.
Hearing. We'll hear you tomorrow, but go through his affidavit also. Just for further hearing. More. Further hearing. Tomorrow.